talk about delinquencies and youthful offender cases today. Okay? And what you don't have is a little bit of history. So later on, when you read some of the mass cases, you may get a little confused. So I want to give you a little bit of the history of the Massachusetts statute where the legislature, enacted the youthful offender law. And I'll get to that, but I want to start with the delinquencies first. So who can tell me, under the Mass statute, what the definition of a delinquent child is?
Reading from my computer.
Yeah, go ahead. Why not? But summarize it.
A child between 7 and 17 who violates any city ordinance or town bylaw or commits any offense against the common law.
Yeah. Crime under, Mass general laws, and statutes, and case law as well, obviously. There's a crime. And ordinance. For example, with regard to ordinance, I gave you for next week's reading material, one of the cases that I gave you is actually the Commonwealth v. Weston case. It's the last case in the juvenile delinquency in Massachusetts cases. That case actually arose out of Lowell, where juvenile had violated the local curfew ordinance. There were all kinds of problems with the Lowell juvenile curfew because while it allowed for a chins type of case, which, as you know from going through with the CRA materials, is a non-criminal case. Worst case scenario is a child might be removed from home, but only going to DCF custody. The juvenile curfew also allowed for a child to actually be arrested and to get a delinquency kind of disposition. So a child's liberty was at stake, etc. And that case ended up going. Actually, Judge Blitzman reported the case to the appeals court, and it ended up going to the SJC. One of our alums, Anna Elliott, actually I frequently place MSL interns with her. She had filed a motion to dismiss based on the unconstitutionality of the ordinance. And the SJC ultimately, agreed. She was trial counsel, and then she wasn't appellate counsel, but the SJC ultimately held that the ordinance was unconstitutional. So anyway, you don't usually see this, a violation of the ordinance, when a child is before the court on a delinquency complaint. It's most usually a violation of, Mass general laws, assault and battery, disorderly conduct, theft, disturbing school assembly that you see a lot, a little bit of been criticized a bit, that particular kind of entry into the delinquency system where sometimes the school system, maybe should be able to take care of a child within the system rather than to have a delinquency complaint issued. But anyway, yeah, you're absolutely correct, Richard, 7 to 17. Now remember when Michael Kelly came last week, this is what he was talking about, that the legislature may be raising the age to 18 for jurisdiction in the juvenile court. So let's talk a little bit more about how it all starts. So suppose that in the handout that I gave you guys last week, Richard Ortiz, he's within the age 7 to 17. He did some stuff at school, right? What did he do, Richard? Okay. Oh, were you not here? I'll give you the handout afterwards. So anybody want to summarize Richard Ortiz's case? Patricia?
Richard was attacking somebody outside of school. It had 2 incidences.
2, yeah.
So he got put on an in-school suspension, and one of the activities was he and the other boy had to research different ways to for behavior. And what he did at the end, he just gave a bullet list or a list of what the administrators and teachers should do. So they said, hey, look, this really isn't adequate enough. They called in mom and went through the same thing. They gave him another session because he didn't adequately perform for the first session. And he came up with the same thing, and he says, hey, look, you asked for this, I gave it to you. You can't tell me how I'm supposed to do it. And he did the same thing again. In other words, looking at what administrators and the teachers could do as opposed to what he needed to do to change his behavior.
So putting aside, his defenses and the possibilities that he was bullied and so forth, let's just talk about the acts that he did. There were two that you mentioned, Patricia, right?
Yeah, he was hitting somebody with a stick.
Right.
Like a hockey stick.
When was that? When and where was that?
That was actually, I thought that was in school.
Yes, it was. Where in school?
I thought it was in gym.
Yes.
Which is where
yes.
you use a hockey stick.
Yeah.
And then the other one was outside of school with a piece of wood.
So the hockey stick, he hit somebody else. Is there a name? We'll just...
I don't think there
Richard
was. It
hit...
said attack
We'll say
wood.
Billy. Okay. So Richard hits
Oh,
Billy.
Adam Troy.
No, that's the principal.
Yeah. No, I don't think so.
Okay, that's all right. We'll make it. So Richard hits Billy in gym class, and I believe the facts said that he broke his nose. So let's leave it at that. Assault and battery, dangerous weapon, which is, and I don't know this, the specific code. It's 265 something, which is where most of the crimes and punishments are included in the Mass General laws. So the scenario that I gave you just dealt with the in-school stuff and the school bringing a CRA, a child requiring assistance. But let's talk about those actions also being the subject of a delinquency complaint as well. All right, so let's just handle that one first, the hockey stick incident. So how does it happen? So on today's Tuesday, suppose this incident happened on Monday, and the kid was injured. The school is going to discipline him, and those are other issues. Remember, under 37H, there could be suspension. The fact scenario gives you that he was, he had in-school suspension, etc. But what happens in terms of the police getting called and a delinquency complaint issuing? So he's under 17. He's what, 15 or 16? I think his affidavit says how old he is actually. Right? Born in 97. Somebody do the math for me. I think he's about 15 or 16.
Yeah, 15 this year.
15 this year. Okay. All right. So if you look at Section 54 of your statute, it talks about the complaint process. So the Commonwealth may proceed by complaint in the juvenile court. Chances are this situation, it's not, he probably doesn't need to be apprehended or arrested. But one of the many sections of the statute indicate that this is more than just a straight criminal proceeding because it deals with children. So both the juvenile and his parents get a summons to appear in court before the delinquency complaint issues. Why do the parents get notice? Just going back to some of the earlier cases that you read about parental rights. So this is that it would be, if Richard Ortiz, in addition to having a child requiring assistance case regarding him, if he's also criminally prosecuted in the juvenile system, it's Commonwealth versus Ortiz. In terms of Galt and the Chapter 119, he also gets counsel. His parents don't get counsel. So remember in the CMP cases and in the CRA cases where DCF could get custody, parents would get counsel. So in none of these cases, delinquency or YO, do parents get counsel. but they are very much engaged and should be in the process. Because why, Jeremiah?
Why parents not get an attorney?
No, well, why should they be engaged in the process if they're not parties?
The legal guardian for.
Yeah, and again, looking back to some of the cases on parental rights.
Due process.
What do you mean by due process?
They have a right to be notified, and they have a right to get notice of what's going on, because of course the child is under 18. So, like Jeremiah said, they're the legal guardians.
And it's not only the right, but it's also the responsibility. Jeremiah mentioned the legal guardian, the responsibility. The court is going to expect the parents or whoever is guardian to be there with the children. And in fact, somewhere in the statute, the court can even issue a summons for the parent if the parent doesn't appear. Richard, you look like you wanted to say something.
I was going to say, just under section 55, when you summons a parent, they're summoned in to speak on the child's behalf as to why you shouldn't find their son.
Exactly.
Now, were they called in too for liability? It sounded like they would be responsible for the other child's medical issues,
Yes,
etc.
yes,
So,
and that's covered by the statute as well. There's restitution provisions as well as provisions where the court could issue actually, an amount that the parent or the child is responsible for. Yes, absolutely. I also want to call your attention. Usually, you see. Remember we looked at 119 Section 1, and that was the whole purpose of the Parent Protection Statute. That talked about best interests and abuse and neglect, etc. And it was the purpose of all of 119. Well, if you look at Section 53, is actually the purpose clause of the delinquent YO proceedings. And there's it's just one little paragraph with some very important language, and it's quoted quite often. And it says that 52 to 63, so all of these sections shall be liberally construed so that the care, custody of the children shall approximate as near as possible what they would get from their own parents. And this is the important section. It says they shall be treated not as criminals, but as children in need of aid, encouragement, and guidance. And then it says proceedings against, in these sections shall not be deemed criminal proceedings. Now, even though that's a purpose clause, it's also in direct contradiction to some of the procedures in the statute as well. So keep that in mind, and it's that juxtaposition that we talked about early in the semester about, are these really criminal cases, are they civil cases? Until now, all of the proceedings in the juvenile court that we talked about were governed by the rules of civil procedure. The delinquency and YO proceedings are governed by the adult rules of criminal procedure. So all of the rules of criminal procedure from beginning to end would apply. So in terms of, for example, motions to suppress and motions to dismiss, and Rule 14 defenses, lack of criminal responsibility, jury trials. Okay, this is where jury trials come up as well. The child has a right to jury trial. One of the cases that you'll read for Thursday is actually a U.S. Supreme Court case, MacGyver versus Pennsylvania. The U.S. Supreme Court has held that because they're not in the nature of criminal trials, the juveniles are not afforded right to jury trial. However, Massachusetts gives more rights to defendants and to juveniles, as you see, and they have a right to jury trial. In fact, they're a separate, each month there's a week designated as, as jury week in the various sections of the juvenile courts. So how does that, I know I'm jumping ahead for a second, but that's one of the first decisions that the juvenile and his parents would make when the juvenile is arraigned before the court. And it's a decision, an important decision, whether to go forward and have a trial before a jury or waive jury trial and have a trial before judge only. Anytime you hear the word waiver of rights, particularly important for adults, but even more so for juveniles. what would the juvenile court judge have to be convinced of when the juvenile waives rights like this?
That no one forced them to do it, no one promised them anything, and that they fully understand what they're giving up and what can happen.
Exactly.
Is that possible, or is that an oxymoron?
Yeah, you know, when we also, you're going to be reading the cases that deal with all of the scientific developments that have been made with regard to juveniles. And the very good question is any of this possible? Do juveniles actually understand any of it? In any event, according to the statute, the juvenile is going to sign the waiver, and the parent, I'm sorry, if the juvenile has an attorney, the reason why I say if the juvenile has an attorney, juvenile can also waive counsel. So there's also an important waiver. The juvenile waives counsel, then the parent is going to be also signing the jury waiver as well. Yeah, have you seen anything like that in your internship?
That's right.
Yeah,
there were two different, just to answer Patricia's question.
Yeah.
I think it depends on the child, because one of the juveniles was like 17, and we went down to lockup and explained to him, because you know there was really he had to plead guilty, like everything was against him. So we had to explain everything to him. Okay, this is the evidence that the DA has, and they have you on camera. They explain everything to him to the T. And then he's like, listen, if you go in front of a jury, they're gonna find you guilty anyway. So if you go in front of the judge, I can say, okay, you accept that you're guilty, and it'll work out in your favor. Whereas another child, you try to explain it to him, he's like, no, well, I want to do this. And it depends on, and even then I still was like, really, do these kids understand how come their parents are not here? But it's never really gonna be perfect.
You got to see it in action.
Yeah.
By the way, it's 55A that deals with jury trials. 55A also mentions discovery, which is just the same kind of discovery of any ordinary criminal case. The right to a stenographer is also in that particular section as well. Since we put the definition of delinquency up again, 7 to 17, and you've committed a crime, or a crime of the Commonwealth, or you violated an ordinance. What's the definition of a youthful offender? That's also in the definitional section under 52.
Person
And it's a little bit
subject-
more complicated.
Person who is subject to an adult.
Wait, yeah, oh, I'm glad you said a person, because in the definition of delinquency, it says child, yet in the definition of YO, it says person, right? Okay. And what age, Ash, for the YO?
14, 17.
14 to 17, and then there's different categories.
You want to list them?
Yeah, could you?
Of course. Has been previously committed to the Department.
Wait, go back up again. Right before that, it talks about a crime punishable in state
An offense
prison.
against the law of the Commonwealth, which.
So basically, you're talking about a felony,
Yep, which if
right?
you were an
Because it's
adult
punishable prison, not house of correction. And what else?
would be punishable by imprisonment in the state prison, and has been previously committed to the Department of Youth Services,
Previous commitment,
or has committed an offense.
or, go ahead.
Or has committed an offense which involves the infliction or threat of serious bodily harm in violation of the law,
Yeah.
or has committed a violation of paragraph A, C, or D
And I believe those are all the gun laws,
of section 10.
so I'm just going to say gun laws, okay?
Provided that nothing in this clause shall allow for less than the imposition of a mandatory commitment periods provided.
Okay. So basically, we're looking at, and for purposes of our scenario with Richard Ortiz, depending on that broken nose, if it does fall within classification of a crime that would be punishable in state prison and is a threat of threat or infliction of serious bodily harm. We're going to talk about the possibilities of Richard being a delinquency case or a youthful offender case in a few minutes. So that's the definition of youthful offender. While a delinquency case starts with a complaint being issued by the juvenile court, how does a youthful offender case start, and who gets to have the choice? You don't have to answer that now, because I want to tell you a little bit about the transfer proceedings first.
I thought it was a state requesting.
What?
I thought it was a state requesting.
Okay, yeah.
Okay.
It's the DA, the district attorney, rather than the court. One of the cases that you will read for Thursday is a U.S. Supreme Court case, Kent, that dealt with the fairness principle in terms of a juvenile being treated as an adult for trial and for punishment purposes. And most states, from almost the beginning of the juvenile courts, at some point on, began to grapple with the problem of what do we do, with kids that can't be rehabilitated and have committed serious crimes. Do we try to deal with them in juvenile court or in adult court? So most states had, like Massachusetts did also have until recently, what was called the transfer proceeding statute. And it was part of 119. And it dealt with whether a juvenile should be treated in the juvenile court or in the adult court. That statute was similar in some ways to the youthful offender statute that you now had, but also was very, very different. So if you have, for example, a juvenile that allegedly committed rape, okay, the Commonwealth would be moved. First of all, you would have a probable cause hearing in the juvenile court that was just like an adult probable cause hearing. Very low threshold. Is it probable, that a crime was committed? Is it probable it was committed by this particular defendant? And that was called the Part A section of the transfer proceeding. But what was really the gut of the transfer proceeding was the Part B. So all of this happened before trial. Okay. Probable cause hearing, and then the Part B dealt with anything and everything about the juvenile, not the trial, but the offense itself, but not whether beyond a reasonable doubt the juvenile had committed the offense, but the seriousness of the offense, for example, whether the juvenile had been previously committed, what kind of school record, what kind of family record. As I said, anything and everything where the juvenile court considered whether this particular juvenile was not amenable to rehabilitation within the juvenile system and should be instead transferred for trial to the adult superior court. And if that was the case, then an indictment then issued after that in the superior court, and the juvenile was held for trial in the superior court, and the trial with the superior court judge giving possibly either a juvenile or an adult sentence. So the transfer proceedings, again, was everything pre-trial, trying to decide what to do with this kid, where this kid should be tried. Everybody with me? And by the way, the transfer statute went through lots of changes in terms of what the standard of proof was, and it progressively made it easier for the state to be able to transfer the kid. Usually after some horrendous crime had happened, there was, uproar and cries, blah, 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 people lobbied, and lo and behold, the legislature always reacts that way, and let's make the statute tougher now. In 1996, the legislature changed everything, abolished the whole transfer system. No more transfers. and it was the chapter 200 of the Acts of 96. So sometimes you'll see that site, chapter 200. It's the session law that amended chapter 119, abolished the transfer system, and instituted in Massachusetts this new youthful offender system. So with the youthful offender system, all trials of kids except for murder cases are held in the juvenile court. So the youthful offender indictment is not in the Superior Court, it's in juvenile court. But the district attorney, and the statute says may file, so the district attorney may proceed by complaint, which is the delinquency complaint, or by indictment. So Jeremiah was right, it's the district attorney's choice whether to proceed by indictment or not. I don't know if you guys remembered the bullying case with the, and I always forget her name, the Irish girl who took her own life. Say it again?
Phoebe? Is that the Phoebe case?
Coates.
What's her name? Phoebe.
Phoebe.
Coates.
Out
In
of what
Hadley?
district?
In Hadley, Mass?
In Hadley.
Yeah,
So
maybe.
I had the indictments, I had all of the cases with me, but they're in my office downstairs. So there were a series of children. The children that bullied her were in fact started off in delinquency complaints. I think most of them started in delinquency complaints, but thereafter the district attorney decided to file youthful offender indictments against these kids. Yeah.
And that's only for the youthful offender that the district attorney can either proceed by complaint or indictment?
Yes.
Okay.
Yeah. So the choice is whether to, and again, it has to fit within that definition that we talked about. An offense, punishable in state imprisonment, threat or infliction of serious bodily harm, previous commitment, gun laws. But it's the threat or infliction of serious bodily harm that gets a little muddy, doesn't it? So with Richard Ortiz's case, hockey stick, A and B deadly weapon, regardless, that's the crime itself. So regardless of the actual injuries of the kid, he may have a broken nose, he might have worse than that. But in any of those scenarios, the district attorney has the choice whether to go for a youthful offender indictment or not. Somebody's hand was up.
So it's a youthful offender indictment, or what's the alternative?
Oh, well, a delinquency complaint, because you're still 7 to 17 and you've committed a crime, right? And again, just like the Hadley kids, it might start off as a delinquency case, because the indictment takes a while too. You know what I'm saying? So it might start off as a delinquency case, and sometimes you actually have a little bit of negotiation. What are we going to do with this case? The kids are in for the first time. Well, I'm thinking of filing a youthful offender indictment, but if he pleads to X, Y, and Z, maybe we could take care of it within the delinquency jurisdiction of the court. You know what I'm saying? But the important thing is, with the old statute, the transfer proceedings were, they were mandatory in certain instances, and they were the most serious cases, similar to the youthful offender. But the decision whether to transfer was the court's decision, whereas the decision whether to indict is the district attorney's decision, not the judge's decision. Okay? And we'll talk about the various dispositions too. I'll get to that.
Is there do they determine whether you get a right to a jury trial based on the severity of the...
No, you have a right to jury trial if you're 7 years old and you've been charged with disturbing school assembly, which is so minor. Okay. You have a right to jury trial no matter what, according to the statute. And you've got to either waive that right, you have to waive that right, or go for the jury trial right at the beginning when you're arraigned. Joe?
I just want to ask, youthful offender, just make sure I get this right. Serious offenses, 14 or older, correct?
Yes.
Can't be younger than 14.
No, can't be day over. Can't be a day younger than 14.
Okay.
No.
Got it.
Got it. All right. And we'll talk about the murder cases and disposition, and we'll get to that. I just want to take things sort of in order a little bit. So, just like when a criminal defendant appears, before the court for the first time at arraignment, you've got all of your rights. Your right to jury trial, your right to an attorney, your right to basically plea, in this case, it's not a not guilty, it's a not delinquent. When the judge, at the end of a trial, if the Commonwealth has proven beyond a reasonable doubt all the elements of the offense, you're not found guilty as a juvenile. You're actually adjudged delinquent or adjudged a youthful offender. And as Section 53 said, they're not supposed to be criminal cases. The Commonwealth, the whole parents' patriarch philosophy having to do with let's try and protect and rehabilitate children and not punish them as adults. Of course, with the old transfer cases and the YO cases that are subject to adult punishment has to do with a whole breakdown of, well, you know what, in this particular case, there can be no rehabilitation, and these are all the reasons why. This child cannot be treated as a child because of the offense, because of the circumstances, because of his character or hers, and what's going on in his or her life as well. So you're appeared before the court, you could plead immediately, plead not delinquent. That means the case is then going to be set and be on the trial, going forward to, discovery, motions, pretrial conference, etc. Or you can plead. And that's what Jadita was talking about when Mike Kilkelly and her were talking with the client about the possibility of pleading. So 55B talks about the various pleas and disposition requests you can have. Anybody familiar with what quaff is, continue without a finding?
Isn't that kind of like it could happen if it was, you got lucky if your first offense for driving under the influence or something, they would say, if you go to this program and there's nothing that happens further in the next few years, then we won't have anything, we'll just continue it, and if you don't do anything else, it'll go away.
So if you're admitting to sufficient facts is basically what you're doing, you're not pleading guilty, or, Tim, you want to say something?
That's what I was going to say. You're not saying you're guilty, you're saying there's significant facts that you could be found guilty, but you're not admitting that you are.
Yeah, and the court is going to continue the case without doing anything after hearing the facts, hearing from probation, hearing from, counsel on both sides. It might be an agreed disposition or a not an agreed disposition, meaning that, the defense could be asking for a quaff, the district attorney might be asking for more. The judge, after hearing the possible facts that the Commonwealth would be able to prove, as well as the juvenile's record, etc., might end up agreeing with the defense and giving the quaff and placing the child on probation, perhaps, as well. You're going to go through X, Y, and Z, and at the end of this period of time, the case would be dismissed. What frequently happens also sometimes is the child might be placed on pretrial probation, and I think that's Section 87, I'm not sure, where you're going to be also complying with some terms of, probation before you even go to trial. All of these options, again, parent and child are very much engaged in the process. If parent is not engaged in the process, in fact, there's a provision, remember we talked about the reasonable efforts. One section of the statute talks about the judge also having to, in compliance with the federal law, if continuation in the home is not going to be in the child's best interest, then, you know, in this case, not DCF, because DCF was the agency for care and protections and for CHINs, for CRAs, but DYS would have to, you know, show the judge that that continuation in the home would be actually contrary to the child's best interest. You know, the parent has to be and should be very much involved all along the way. And that gets into, you know, in terms of role in counsel, can be really tricky. You know, you're appointed to represent Richard, and there's his mother right with him that wants to talk to you and talk about what the strategy should be. So you have to also be careful about that, where we have the client-directed model in Massachusetts, and you want to be able, yes, to involve the mother in terms of understanding the process as well, and he or she can also be explaining as parent the child's rights as well. But it's the child that you represent, not the parent. And you want to make sure that the child is making an informed choice, no matter how young the child is. So keep that in mind. So those are the possible pleas you can make. What can happen after trial? Adjudication is section 58. So obviously burden of proof, because these are criminal cases, is beyond a reasonable doubt. Child doesn't have to do anything. Remember, with the care and protection cases, if the parent didn't take the stand and testify, there could be this presumption of unfitness. Obviously, that doesn't go in criminal cases. The child doesn't testify. The child has a right not to testify. So all the same rights, pretty much, that, you know, adults have, and also the rules of criminal procedure would apply at the hearing, at the trial, if the child elected to go to trial. And then the judge has choices if the Commonwealth proves its case. Worst case scenario, let's go with the worst case scenario first of a delinquency case. 7 to 17, and you committed a crime. Commonwealth proves beyond a reasonable doubt. So the adjudication phase of the trial is over. Now the court's going to consider what it should do, the dispositional phase of the trial, which could occur just immediately right after. What's the worst case scenario?
In worst case, you're talking delinquent, not youthful offender.
Yeah.
So they can be confined to DYS until age 18?
Actually, it's 21, I think, Joe.
So that's what I was going to ask you. That's the question. I saw two different parts of that. One was talking about youthful offender. I was looking actually at the new printout from the Commonwealth of the law changes.
Yes.
And it talked about two different ones. One talks about till age 18. It talks about intermediate sentences taking both.
Yeah, that's the apprehension after age 17. Yeah, but what we want to look at is section 58.
Yep.
Adjudication as delinquent child. Yeah,
okay.
And that's till 21.
So the other.
So in terms.
Sorry, I was just
we'll
gonna
get to those sections.
Sorry, all right.
Those are so confusing.
Gotcha.
But in terms of adjudication, worst case scenario is this kid, who might even be at that point 17, DYS. 21. What's the least sort of restrictive scenario?
Either be a QUAP or adjudicated delinquent and placed on file.
Yeah. So if you look at the sort of the first paragraph first, there's adjudication of delinquency or a QUAP with participation perhaps in, you know, probation and community activities and whatnot. And if you're going to get the QUAP, you're not going to be adjudicated delinquent, because obviously it's not an adjudication. I just want to make sure you guys understand that. So the adjudication of delinquency has to do with the commitment, placing on file, on probation, or DYS. On file, probation, DYS. You're still adjudicated delinquent. You continue without a finding. The on file thing always confuses me because I never understand how that is any different than a quaff, but it's the court places the case on file and places the child in the care of a probation officer, which again is so similar to just being on probation too. The only way I remember it is that a quaff is nothing, and it's just like, listen, okay, whatever, come back, we'll entertain this case a year from now. Hopefully you don't have another charge within that year, because if you do, then the quaff changes. Ash?
Worst case scenario for a child that's adjudged delinquent would be to be committed to DYS, but
yeah.
also jail time too, right?
No, no jail. We're going to get to that with YOs.
Okay. I was going to say that even though the quaff is looked at as being like the least restrictive punishment,
yeah,
a lot of times it's more severe because
it hangs over the child's head.
If you're adjudicated delinquent and it's guilty filed, he walks out of the court that day, sometimes without even probation.
True.
If he gets a quaff, then he's got all these conditions, and if he doesn't meet them, he comes back.
Very good point. And you have to make sure that the child understands that. And also just in terms of probation, they're so very quick to, let's agree on all of this, bing, 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 bing. And then if the child doesn't comply with the terms of probation, now you've got, and I forget what section it is, the violation of probation hearings, section 59. You're at the mercy of the court. There's nothing you can do, whether you're an adult or a juvenile. If you've been violated, it's whatever the probation officer wants pretty much is going to happen at that violation of probation hearing. So you're absolutely right. You want to be really careful. And also with this pretrial probation stuff that I talked about earlier. The child and the parents, of course, again, have to be really clear on what the child has to do to comply, and can the child do it? Will it happen? So you don't want to place them in any situation where they could possibly be, violated. So let's compare, as we're going back and forth, so let's compare the YO kid. YO case goes to trial. Now this is, I mentioned the transfer hearings. In the old scenario, you had transfer hearing first, trial second. It's pretty much kind of, in a way, reversed with the youthful offender cases, because what you're having is you're having the trial first, and it's in the juvenile court. Criminal case, burden of proof on the Commonwealth, beyond a reasonable doubt, adjudication phase is now over, right? It's the disposition phase of the youthful offender proceedings that are much longer, or can be, depending on, what kind of evidence you have and whatnot. The test or the standard, and it's in, again, I'm still in section 58 of the statute, is public safety. It says the court shall make a written finding stating its reasons and the present and long-term, that the present and long-term safety would be best be protected by, and then the three kinds of possible dispositions. Very different from the old transfer hearings where the focus was on the juvenile and the possibility of being rehabilitated. Whereas with the YO proceedings, the focus is on the safety of the public. So there's three possibilities and three possibilities only. Once a YO case goes to trial, at sentencing, what are the three possibilities?
A sentence.
1, 2, 3. What?
A sentence provided by law.
Which is what, really?
Adult sentence.
It's an adult sentence.
Yeah.
We'll talk about that. And the second one is?
Split.
The combination one?
Oh, yeah.
Which is adult and juvenile. And then lastly, a juvenile sentence. So when the court talks about the sentence provided by law. It means whatever an adult would get, a juvenile would get. So obviously the worst possible scenario for a juvenile. The combination sentence, they're going to start off in DYS, then a house of correction or a state prison after that. And then the juvenile sentence, just like the juvenile sentence in delinquency cases, DYS till 21. That same section, 58, talks about the factors. And the factors in the sentencing hearing are pretty much identical to the old factors in the transfer hearing. The seriousness of the offense.
So the transfer hearings aren't done anymore?
No. The transfer hearings aren't done anymore, but what's important, Patricia, is that the sentencing hearing factors where the court will ultimately determine whether this kid gets an adult or a juvenile sentence were the same factors that were used in the old transfer hearings. It was the seriousness of the offense, the victim statement, the history of the kid, past treatment efforts, his age, his maturity, possibility of future criminal conduct. Again, and most of it amounts to possibility of rehabilitation and seriousness of the offense as well. So the court looks to also, I've been mentioning probation. Probation is very big in all of these cases. In fact, when a juvenile is first apprehended, I think that's section 67, when a juvenile is first
Notice to their parents.
Notice of arrest.
Is it 67? Where am I? Yes.
Detention.
Yeah. If a child is arrested or picked up in any way, who gets notice first? It's the probation officer as well as the parents. If they're going to, promise that the kid will be coming into court, the parents get to take the kid and then bring the kid, into court. By the way, in terms of being detained, there's two ways that children are along the process that are possibly not within their parents' custody. Okay, they can be detained pending trial, and there could be many instances of that. Detained pending trial, for example, if it's a youthful offender, seriousness of the offense. The adults bail statute, which is 276-58 and 58A, applies to juveniles. So, for example, 58A is what's called a dangerousness hearing. Was a fairly new, I'm saying in the last 10, 15 years maybe, statute that allows the Commonwealth to bring this proceeding where pending trial, an adult and SJC has held juveniles apply as well, can be held pending trial if the offense with which he or she has been charged is pretty much a dangerous offense, and the public, safety might be undermined by that individual being, out loose pending trial. So a child can be detained, for example, for any kind of diagnostic or mental health study as well. A child perhaps or his parents can't make bail. Just like the adult bail statute, you have the right to go to a Superior Court judge immediately and appeal whatever bail determination the trial judge, has made. If you're held in any way pending trial, in Massachusetts we have what's called this 15-day rule. You have the right to be brought before the court, every 15 days. Same, almost same rights that adults have. The cross-references to the bail statute that I mentioned. All of the constitutional rights, pretty much, that adults have. what if the child gets an adult sentence, the sentence provided by law, and the child is 16? Where does the child go? What's important is the child is not going to be, go ahead.
He'll be still sent to prison, but he'll be kept in the youthful offender unit.
Yes.
And then once he becomes an adult, he gets transferred to general population,
Yes.
which is usually pretty bad.
Really bad, yeah. Are these trials open to the public? Janita said no, is that correct? There's a catch here.
Depends.
Depends on what, Jeremiah?
I don't know. If there's a catch, it must depend.
If they're 16, does that change their status?
It's not, doesn't have to do with age.
The crime or the charge?
What do you mean by that?
I think youthful offenders are public. The other
Absolutely,
offenses are not.
yeah. So delinquency cases, just like the CNP cases and the CRAs, public can come in. Youthful offender cases are not closed cases. However, they're held in the juvenile court. So it's kind of tricky in terms of, can you really get in there? First, you know, those of you that have come so far, have gone so far to any of the juvenile courts, you know that, you know, the court officer is at the door, very careful about, even if you're a student intern, you know, where's the lawyer? And even, I remember that Jeremiah and, no, it wasn't you two. It was two students from the night class, actually, were observing one morning, and then they saw Chris Cook, and Chris Cook was going to take them into another session to see a care and protection case. And actually, one of the attorneys objected for her client that they didn't want anybody else in there. So when I say closed, they really are closed to the public. It's very nice that the local juvenile courts do, and you know, allow some of our law students to observe some of these proceedings. They can get
Is that
pretty, you know.
because the youthful offender has maintained most of the criminal procedures, so that's why it's open to the public?
Absolutely, yeah, yeah. That age of 14, remember we've seen it in many other places in terms of child maturity and so forth. Notice that that's the cutoff point for youthful offenders, 14 to 17. Joe?
I was just going to say, and I know it's different state by state, but in New Hampshire, we have a small court for, we have an adult court, but they have a sitting for juvenile session.
Oh, yeah.
And
we used to do that.
the judge actually makes the court officer keep a log of exactly who comes in, and even police officers, you have to list why you're there, what case, if there's a witness there, why they're there, and the judge checks that before he starts the proceeding. I don't know if it's legal or not, but what he does.
Now, what if a child 14 is charged with murder in the first or second degree?
Delinquency?
Go to adult court? Are they trying to be an adult? Or is that
14.
have to be 17?
No, if I needed to create a third section on the board, it would be for
Has to go to district.
Superior Court, murder 1 and 2. Court has no jurisdiction. And we'll be reading for next class the Miller case. Actually, we'll be reading the death penalty cases of Roper v. Simmons, and then the life sentence cases, Graham v. Florida and Miller v. Alabama, which kind of puts a twist on what's going to happen in Massachusetts after the decision of Miller v. Alabama. That actually just came out last June. What's important about a juvenile being charged in Massachusetts with murder 1 or 2 is that our murder 1 statute, you know, calls for no discretion on the part of trial judges in the Superior Court that if a defendant is found guilty of murder one, the defendant gets life. So there's no dispositional hearing, to consider circumstances. It's basically just life. So that has to be changed, and I'd like you guys to read the Miller case for the next class, and we'll talk about that.
Didn't they come up with legislation that doesn't allow anybody under 18 to be charged with life?
Who's they?
I thought wasn't that the Supreme Court?
That's
the case. That's the case that you're going to read for Thursday. Massachusetts is, as most states, currently deciding what to do because it's actually the combination of Chapter 119, 60, whatever. 72. I'm sorry. And 265-2, which is the punishment of life. It's the combination of those two statutes that allow a superior court that mandate a superior court judge to sentence a juvenile for life. Who was the kid that? Where was it? I'm trying to think where, but he knifed a kid to death in the bathroom. How many years ago? It's only been maybe 3 at the most. And he wasn't autistic, but what's the other thing?
Asperger's.
Asperger's. Anybody know who I'm talking about? I always forget his name. He's doing life right now, so I don't know.
He was in a school.
Yeah, in the bathroom. He knocked the kid to death.
Was that in Concord, Lincoln?
It was one of those.
It was in a fairly Sudbury. It was in a
Sudbury. That's where it was. It was Sudbury, and I'll remember his name maybe for next class. But so you have cases like that the courts and may have to make decisions about. Then children, now adults, already in custody, doing life, but also what to do now about the future cases. And whether it's the legislature that has to change, or the common law that has to change.
Ogren?
What's that?
Was it Ogren?
Yeah, Ogren. Yeah. What was his name? And he was...
John Ogren.
Yeah, he was... maybe 15, 16, something like that.
He didn't have a clue what he was really doing, did he?
What's that?
15.
He was 15. As was, and this goes back even further, it was Eddie O'Brien that actually spawned the legislative change of the youthful offender statute that I've been talking about for the last hour. Eddie O'Brien was only about 14 or 15, big kid, and he knifed to death like 93 times his friend's mother. And he ended up getting life, but under the old transfer. Did he get life? Did he? Yeah, I think he did.
How old was he? Was he 14?
Because his case went up and down and went to the appeals court, SJC, etc. But it was that case that all of the uproar from that case spawned the youthful offender statute. And I'm trying to remember if he did or not. I think so. I think he was transferred ultimately and found guilty of murder one. I think that's what happened with this case.
Now, before they get rid of the state mental hospitals, would some of these young people have gone there?
Yeah. Yeah. See if there's any other section of the statute that I need to point out. The 15-day rule that I talked about is section 56. And the reasonable efforts is actually in the last paragraph of that long section 58. That's the adjudication as delinquent child or youthful offender. The very last paragraph talks about the Federal Adoption Assistance and Child Welfare Act of 1980. That was the federal act that originally contained that reasonable efforts requirement. So the court still makes, even in the delinquency cases, a reasonable efforts certification if the child is going to be removed from the custody of his or her parents. Then section 29 is the violation of probation that I mentioned. 60A talks about the youthful offender cases being open to the public. And then 62 is the restitution or reparation, as they call it, section. 65, the close exclusion of the public from all of the others, except for the YOs.
I have a question. Do
And
they
those are
have,
most of the really important, the sections that I want you to at least be familiar with.
I have a question. For the youthful offender cases, do they have a right to ask for a closed trial?
Well, give me an example.
Like, for example, the case you were just talking about, because those cases that they're open to the public since they're criminal, more than likely, can the
Let me put it this way, can an adult think about ways in which an adult might ask
So
for
that would apply.
a trial being closed to the public?
Okay.
So again, it's open to the public. They don't have the right to the privacy that the juvenile trials have, but there may be reasons why the court may order,
Okay.
that the public not be included. But, it would be different from, they don't have a right to.
Okay.
So basically, you want us to know 50, 29 in the 50s and 65?
As long as you think about, what I want you to think about mostly is, the rights that children have, the differences between the, these cases being cases about children, and yet the criminality of the cases. When I say the criminality, the due process rights, the procedural due process rights, the constitutional rights that are contained in all of these sections. I think that what we'll probably do is we'll talk about the U.S. cases, and notice that I'm asking you to just take another look at golf again, because that really is the case that set the stage for all of these procedural due process rights that juveniles have under our current statute. And then I mentioned MacGyver, the no right to jury trial, so some of the earlier cases, and then obviously the cases that then did away with the death penalty and mandatory life for juveniles. And then next Tuesday, we'll go back to the Massachusetts procedures in terms of some of the Massachusetts case law that's particularly important. For example, we have in Massachusetts, the interested adult standard. Again, in terms of waiver, in terms of admissions and confessions. Going back to why juveniles should be treated, differently and not 100% like adults in terms of rights. And more than likely, we're going to skip the search and seizure, because what I usually do is I do the review last class, and I know we're not going to be able to get to the search and seizure cases. You have them if you ever need them, in terms of, if you're interning for someone, or if you're practicing on the outside and you have a kid that's involved in a school case. For now, those are the important both U.S. Supreme Court and Mass cases that deal with search and seizure in the school setting. But I'm pretty sure that we're not going to go over that, which means that I won't ask a search and seizure question on the exam. We ended a little early. Anybody have any questions so far?